Now we are going to discuss a very important topic. Can a director claim salary under Insolvency Bankruptcy Code IBC? So NCLAT and Supreme Court verdict explained in this video. NCLAT held that no operational debt arises in favor of a director in the absence of independent board remuneration, board approved resolution, and that the existence of pre-existence disputes bar admission of petition under section 9 of IBC. So on 7th May 2025, very recent judgment, the National Company Law Appellate Tribunal, Principal Bench, comprising Justice Ashok, Bhushan, Chairperson, and Mr. Arun, Baroka, technical member, reviewed an appeal and held that where directors' remuneration is contingent upon their employment role, such as CFO, and there is no board resolution or contractual provision authorizing separate compensation for directorship. Any claim for such remuneration after termination of employment does not constitute operational debt under IBC. So consequently, the existence of pre-existing employment disputes renders an application under section 9 of the IBC non-maintainable. So the legal issue in Company Appeal 80 Insolvency number 353 of 2020 arose from dismissal of section 9 application under IBC 2016 by NCLT New Delhi. The NCLAT, first NCLT New Delhi, the NCLT through its order dated January 29, 2020 held that appellant's claim for outstanding dues was based on employment dispute, and that too pre-existing. Dispute barred the application under section 952D of the code. So the appellant had filed the application asserting operational debt on account of unpaid salary after cessation of his role as a CFO, but during the period when he allegedly continued as a WTD, whole-time director of the respondent company. So upon appeal, the National Company Law Appellate Tribunal initially reversed the NCLT's findings on 25th August 2022, concluding that the existence of writ petition and existence of writ petition did not amount to a valid dispute under the code. So the appellate tribunal then held that the appellant, having served as a whole-time director from 1st April 2019 to May 20th 2019, post his CFO termination, was entitled to emoluments for that period because post cessation of CFO, he continued as a whole-time director. So this it held constituted operational debt under the IBC, and the case was remanded for admission and further proceedings. However, the Supreme Court in the civil appeal 5923 of 2022 set aside the NCLAT's decision by order dated August 14, 2024. So the apex court remitted the matter back to NCLAT, directing to re-examine whether there was any entitlement to salary for the appellant's directorship after his CFO. Because CFO role ended, so after that he continued as a WTO. So the Supreme Court remitted back to NCLAT, directing to re-examine whether there was any entitlement to salary for appellant's directorship after CFO. So especially the absence of clear documentary evidence to that effect, because there was no documentary evidence for entitlement of salary as the director. So pursuant to the Supreme Court directions, the NCLAT reheard the matter and thoroughly assessed the employment contract, board resolution, and MR1 and MR1 filed with ROC and payment records and the articles of association. All the records have been thoroughly verified by NCLAT. So it was established that the appellant's WTD, whole-time director designation, stemmed solely from his position as a CFO, and that there was no independent basis or board approved resolution entitled him to separate remuneration as a director. So the tribunal noted that the Form MR1 was merely a statutory disclosure document and would not substitute for substantial proof of entitlement. So the tribunal found that the appellant did not perform any duties as a director after March 1st, 2019, and had raised objection to his termination immediately through legal notices and a writ petition indicating the existence of pre-existing dispute. So the financial disclosures cited by appellant were found to reflect salary paid in his capacity as a CFO, not as a director. As such, his claim for additional remuneration post-termination of CFO was not supported by any evidence or governing company resolutions. So, the NCLAT concluded that the appellant's claim did not qualify as an operational debt under the IBC and reaffirmed that the dispute was contractual in nature governed by the employment agreement. So in the absence of clear entitlement or unpaid dues arising the course of business transaction, the appeal was dismissed. And the order of adjudicating authority rejecting the Section 9 application was upheld. So please subscribe to RR Corporates, and we have other channel, RR Legal Tax, RR Corporates, and RR Legal Talks for more legal updates. Thank you.